order. And this is a hearing on whether to allow a rehearing or not on a previous case that I was not present for, so I can't talk any about it, but that's what it's all about. We'll start with me. I'll introduce myself. We'll go around the table. And then is the applicant in the room? No, sir. Not?
No, they are not.
Okay. Doug Cowie, I'm the chair.
Mark Kennedy, Land Use Administrator.
Reagan Elliott, member.
Frank Albert, Vice Chair.
Wayne Morrill, member.
Christopher Perry, counsel for the Town of Brentwood.
So everybody has the paperwork in front of them. Letters of motion for a rehearing, appealing the decision of the Board of Adjustment of December 17th. And the issue, well, you can all read it for yourself and spare you that, but has to do with the square footage allowed on the sign on the building, or signs if multiple signs are allowed. And it appears that there's either the request was not clear to the board, or that it was not clear in the applicant's mind, possibly, of what they were entitled to ask for in the first place. So that's where we sit. My personal opinion is that we have nothing to lose by allowing a rehearing. And boards of adjustment are supposed to be fair. We're supposed to be the fair or leveling part of the process if things go awry. Okay. Okay, somebody jump in here.
I agree with you, sir. I was present for that meeting, and whether, like Mr. Morrill said, I think they had mentioned that the size of the existing sign was different than 108. I think you are correct. I think you said like 65?
Correct.
So we were basing things on that. So we were given incorrect information. I think he didn't know the size of the sign. So in lieu of that, I think they should have a rehearing, I think. That's my opinion.
Yeah, I would agree too. I think, my question to the applicant was what the existing size of the sign was, and he didn't have that information. So our judgment was based on what he thought it may be, and now there's new information that he knows the actual size of the sign. So I think we should have a rehearing so that he can present that case.
Absolutely, there's no downside.
Okay, then there does not appear to be any dissension on the board or disagreement. So my ruling would be that the applicant will be allowed to reapply and have the whole thing reheard and resubmit his information. And it would be helpful perhaps if our administrative assistant would give him a briefing on you can ask for what you're entitled to. If you have to know what you're asking for. And it's not a cumulative, just make sure that it's clear in their mind what they are entitled to according to the rules. And if they want an exception to any part of that, once that's clear, they're entitled to ask. We won't take away anything that they are entitled to under the zoning regulations. The rest we would have to consider based on whatever.
No, what will happen, I believe you just made a motion. That's what I heard, right? So let's disperse of the motion and then we can talk about this, okay?
Works for me.
So we have a motion on the floor by Doug. Motion to grant the rehearing, correct? That's your motion.
It is.
We need a second.
I second it.
Seconded by Frank.
Yes.
You would say all in favor?
I can do that. All in favor?
Aye.
Motion passes. So what,
Opposed? Very quiet. That's good. Okay.
so what will happen is the applicant will have to reapply all over again. They are very well aware of the information that was, what information was not existing in their application. They will submit that application in full, just like it's a brand-new ZBA hearing. And the information that wasn't present with the first hearing will be present at the second. So it's basically a clean slate, basically what you're doing, is you're wiping the slate clean and we're gonna start all over again. I'll have to send out abutters notices, it's a whole fresh process. Fair?
I think it's more than fair. Or at the very least, completely fair.
We might have some public comments, sir. If you could come to the microphone, Mr. Stephen. If you are accepting public comment, sir. Are you accepting public comment?
Yes.
Bruce Stevens, South Road. I think maybe we're council's here tonight, this evening, that he may enlighten us a little bit. When you read the statute on an application for a second hearing, it talks about substantial new information. And I guess I would just ask the board, for the record, did the applicant at the first hearing give us the information that the board made a judgment on? So I guess, I'm trying to understand if this is this new information, council? I assume that the information from what Mr. Morrell said, came from the applicant at the first hearing, in terms of the size of the sign. I just like to understand. I think it's learning for the future too, of what constitutes grounds for a second or a rehearing.
Yeah,
So did the applicant, for the record, did the applicant give the board the measurement of the existing sign?
Yes.
members?
They
But
did.
he didn't have the actual sign dimensions with him at the night of the hearing.
Right, isn't that his responsibility?
I thought that if he was asking for a variance for a second sign, that he would have known what the existing sign was so that he would know the total square footage.
Well, I'm just trying to understand that threshold for substantial new information that would be the basis for granting a rehearing.
Well, I think his, then after the hearing, coming up with the actual size of the sign being 108 square feet, that was information that he didn't have at the time of our judgment. And so I consider that being new information that was not present at the time of the hearing.
Might we ask counsel for, this is the NHMA, Doug, the coursework from the session that we had with the NHMA municipal attorneys 2 years ago, where we went over criteria for a rehearing. Thank you.
This board can ask me, but unfortunately the public can't, respectfully.
I would just like to, have the board make a comment on the record as to the applicability of the standard for rehearing. Thank you.
Is there, I don't know, you tell me if I'm not asking you right, a question that belongs here. Even though the person who was testifying, I think he was the person who puts up signs, does he, was he the applicant? Okay, okay, because this Carolyn Parker, who who she is. She knew, and that's what I'm wondering if she knew. I don't now. Now I don't know who she is.
Carol Parker was acting, for council's edification as an agent for the applicant.
For the applicant. Okay, I thought he was there because he was going to be putting the sign. Okay.
That's a correct statement. Carolyn Parker was the contact person who applied for the variance. The person who showed up actually works for a signs and awnings company that Carolyn Parker subcontracted to build the new sign. So your statement would be correct, that the person that came to the meeting was not Carolyn Parker, the actual person who applied for the variance.
So which of the two, if she knew that it was 100A, is that relevant, even though he didn't?
There was nothing in her documentation that was supplied to you, and I urge you to go back and look at the file. I can resend the link if you wish. There's nothing in that documentation, to the best of my knowledge, that had any dimensions of the existing sign.
It was the letter sent to you from Carol.
This letter is the letter for rehearing. Actually, it's the second page. This is the letter she submitted for rehearing.
But isn't the evidence presented by the applicant, that's part of the record, and that's what was in their original request, correct?
Is that a direct question to me, Mr. Stevens?
Yes, I would, as a taxpayer of Brentwood, I would appreciate, where counsel is here, that he would perhaps enlighten us, and again, not just for this hearing, but for future hearings, as to how that standard is to be applied.
I mean, to speak very broadly about the standard for new evidence, in general, it would be just evidence that was not available to the board that would have enabled the board to have made a decision in a certain way. So just it could be something that was not known to either the applicant or the board, or it could be something that was known to one party but not the other.
I don't want to belabor this, but I think when an applicant makes a presentation to the board, that's the evidence that they're giving you for making a decision. And I think if it's their fault, or, I mean, it clearly, I think the burden lies with what they tell you. And they did tell you, I mean, it's easy to say afterwards, well, I made a mistake, but I think that the judgment of the board should stand because they had every opportunity to present evidence to support their case. And how do they go back and say, well, I made a mistake? I mean, anybody could say that. And I'm just trying to get to the point, again, for future hearings too, what that threshold of new information is. Where does the burden lie?
My only other answer to that is the reason that the rehearing process exists is to give the board or applicant a second chance, a kind of a do-over. I mean, the evidence standard is going to be a lot lower than it is in court, which is where you're kind of talking about the burden of proof being like on the applicant. Yeah, again, it's going to be a lot lighter than a court proceeding because of the nature of the ZBA, because it's a informal hearing where you don't have to appear with counsel. The rehearing process exists as a legislative safety valve for any kind of error that may have occurred in the initial ZBA hearing.
Okay, and for what it's worth, my opinion would be, since the CBA exists simply because planning boards can't plan for everything, or more simply put, very few people in this world are perfect, and they're not. If they were all perfect, they would not all be in this room or in Brentwood, for that matter, I suspect. So I think be open-minded about it. I don't think anybody came in here with ill intent. I think that it was just a poor judgment, abuse of manpower to do the presentation. I doubt if they'll make that mistake again. And I think they should have, and some people get some money tied up in this project. It's not a scar around Brentwood's neck that it's here in town. I think it's good for the town. And I think we should be as fair as we possibly can. And certainly give them a chance to do it one more time and see if they can do it a little better or considerably better. And we can come up with some kind of a middle ground, if nothing else.
And just to be clear, Mark, the applicant is going to be financially responsible for abutters notices and all of that.
Correct. It's a clean slate. We start right over from square one.
Thank you.
Yeah. I find it interesting when you speak about the standard, and it's a broad standard. I guess it would have to be a case-by-case basis that you'd look at that standard on.
Oh, yes, it's very fact dependent. It's
Right.
And it's up to the board to determine what those facts are. So
Right.
a board could take that approach and say, look, whatever the applicant says, we take that set in stone, or it can take the approach that, if the applicant made an error and now says we made an error and this is information you didn't have, then that's information the board didn't have, so it can have a rehearing. It's very fact dependent, for sure.
Thank you.
Thank you.
There are other things on the agenda if you'd like to keep moving on, sir.
You mean we gotta do that too? Okay. Next thing on the agenda is approval of the minutes from December 16th. Do we have a motion?
I'll make a motion that we accept the minutes, meeting minutes of 12/16/24.
And do we have a second?
I'll second.
Okay, we have a motion and a second to accept the minutes, approve them. All those in favor?
Aye.
Aye. Opposed?
Was that unanimous? Miss Elliott? Was that an aye?
Were these the same minutes that we have?
They're the same exact minutes that I sent you.
Oh, okay. Yeah, I have one. I do have one. I just saw it here on the.
That was an aye? I didn't see a verbal cue from you. That's why I'm
Yeah, no,
asking.
because I was looking for this. I didn't think to look on the back page, but I just found.
Thank you. Thank you so much.
I don't know how it helps to have Garber's statement, I'm leaving this meeting, you don't have a quorum now, then walks out of the room. I don't know how why do we need that? So I object to that. I know he left the room. He said he
Sure,
did.
sure.
But that kind of a statement,
Mm-hmm.
anger.
So are you saying that isn't factual?
I'm saying it could be misinterpreted, and I don't think it helps the minute. Oh, sorry.
You're
I
fine.
think it can be misinterpreted, and therefore I don't believe it adds anything to the minutes either.
Mm-hmm. Would you like to make a motion to strike that from the minutes?
Yes, I make a motion to strike the sentence that starts at 7:47, Jay Garber says, and then the quote.
Okay, team, we have a motion before us to strike that statement. Is there a second, so we can at least discuss it, if nothing else?
I'll second the motion. I'll second the motion.
Okay, it's been moved and seconded. Does anybody want to speak to it first? Or are we ready to vote one way or the other? Very, very quiet, okay.
Is the
All
person
those in
who
favor
makes
of
the
the
motion
motion?
allowed to speak?
Absolutely.
Okay, so I just want to make sure that it's clear. It does say that he insists the application should now be before the ZBA, and he, and then that he left the room, and I think that's all that should be included.
So what your motion would be to strike, I am leaving this meeting, you don't have a quorum now, would be those
Yeah,
words.
yeah, I'm
But you're
not-
not striking it for a factual reason, you just don't want it printed in the minutes, correct?
The facts are not wrong, if that's what you mean. They're not wrong. I think that they don't belong in this, into this paper. Somebody who doesn't know what
Mhm.
happens reads this. I think it could be misconstrued, and I don't think it helps. I don't see why it would be there.
Fair, your motion stands, it has a second.
I guess just a question. So are we gonna keep in there at 7:47, Garber left the meeting and walked out of the room? Is that gonna stay, or is the whole thing being struck? Because I think we have to acknowledge that he did leave the room. That's a factual point. So
But
if you wanna, I can see striking, you don't have a quorum now.
that's exactly what I would.
If you'd
yes.
like to strike that, I would
Yeah, the
second
fact he
that.
walked out of the room is,
Yeah,
I would have to seek the advice of town council, that if something is going to be stricken from the minutes that is factually true, can you strike that from the minutes, sir?
Yes. You can't redact or conceal what happened. But if the minutes still read at 7:47, Jay Garber walks out of the room, that still contains possibly the factual components of that. We could discuss it more in a non-public session if the board wanted to. But I mean, generally, this is a valid correction to the minutes. I'm obviously going through Robert's rules right now to like check on corrections to minutes, but yes.
Thank you.
Okay, so the redaction of that part of the conversation has been moved and seconded. All those in favor, raise your hand. Opposed? Seeing no hands? It's a done deal. Okay, any other comments on the minutes? And hearing none, thank you. All those in favor of the minutes as corrected, raise your hand. See 3 ayes. Those opposed? See nobody opposing it? It's a done deal. You know, I'm sitting here thinking it's a darn good thing, don't have to go through all this at the school board meeting, town meeting, and argue about the minutes of it. I'd frankly be there for a month, 2 months, 3 months. But, hey,
I have a question. If I may ask, I know we approve for them to have a rehearing, but whose responsibility is it? Whose responsibility is it to tell us the size of the existing sign? That's what I went through their paperwork from last time, and there's nothing on there that says the size of the existing businesses sign. So that was a blind spot. And but whose responsibility, is it our responsibility to know the size of the business's signs?
I would say it would be your responsibility to gather as much information as you need to make a decision. Now, what you could have done procedurally is say, hey, I don't have enough information here. Let's continue this to the next meeting. I need this information to make an informed decision. And I guess that's one of the advantages that I would say the planning board has, is that it takes multiple meetings to get something approved. And you can always ask for information, then it comes in the next time you have a meeting. So I wouldn't be, if I was in your position, I wouldn't be afraid to continue a hearing if you didn't have the information that you needed to make a decision.
Right, but I'm just trying to understand it, because in the paperwork that I have, I don't see anything that tells me the size of the existing sign.
Mhm.
So we miss that. And someone's coming, asking for additional signage, but we don't know how much signage they have now.
It's an interesting question because
So,
it was a direct correlation of the approval. With the approval, you had conditions, and in that conditions, it gave a very specific set of numbers.
right.
And
But that was given to us verbally by the contractor, not the owner of the property, not the business, but the contractor who's putting the sign.
right.
Okay, I'm just trying to understand.
Okay, and Mr. Stevens, you have a question?
You know, I believe testimony can either be in the written record or the verbal record, and I believe that the applicant stated what the size of the sign at that hearing. So I believe that he was agent. He's basically for legality purposes, I think. I'm not an attorney, and I'm not even pretending to play one to you guys because you know better, but the agent really is speaking on behalf of the applicant. The applicant has given permission for an agent to come before the town and apply for this variance. So I do not think in any way, and I don't think council will tell you this, that you guys are responsible for going out and put your tape measure up. I think you take the evidence that the applicant gives to you in good faith. I mean, we all assume everything's in good faith. So definitely, the board did not make a mistake. Mark's point about continuing hearings is a very good thing. Everybody likes to have a hearing, make a decision, put their hand up, and vote. But practically, the town is better served if such a situation. In this case, you guys weren't aware that there was even a question as to the difference in the sign square footage. So you did your work correctly, I think. And I think it's, again, the burden of the proof lies with the applicant who made the statement on a public record. Thank you.
Well, and another way to look at it, for a guy who wasn't there, the assumption when he comes through the door is whatever they were allowed to put up for a sign on the front of the building, they're a damn fool if they didn't put up every square inch of it that they're entitled to. You just assume that somebody says, you know, you want a dish of ice cream, you get a full dish. What the hell? So, and then to have them, the tip off on that is, the comment I think in the reapplication, some of them, goodness, was that they felt they didn't get their fair share of signs. Well, how would any of us sitting here know that if they didn't tell us what it measured to start with?
So had she been there, she probably would have at that point said, wait a minute. I mean, because he didn't know it was 108 apparently, but this Carolyn Parker knew. Had she been at the meeting, she would have said, this makes no sense. You're giving us, and that, you know, because she knew about the license that they got a long time ago. With the 108. So I'm just presuming that he came from the sign company without all the information, and he came back and gave it. She said, this is not what we wanted. It should have been here. Well,
You know, sometimes it costs money to make mistakes. We lost time. Gotta
Yeah.
Go through the whole thing all over again, and there's no guarantee they come to it going through this time. They still get a chance to screw it up again, so, hey,
It takes time on our part too.
well, it
because,
does.
You know, when we go to the hearing, we'll make sure now we have everything straight.
See, I consider this to be tongue-in-cheek, a unsupervised field trip on my part.
I like that.
From time to time, when I want to pull her leg, I introduce my wife as my immediate supervisor. And I think I'm closer to the truth than not. But she's a pretty good sport about it, so.
So Mark, while we're still on this, you know, I made that motion to the 120 after what he told us, and then trying to find a common ground. But if this sign was at 108 square feet, do I, as a member, now have to go digging to find out if that sign was approved under the current regulations of half and they got something, or do I have to go see if they ever got a variance for the original sign that's up there? Is that my responsibility as a board member to start digging into applications
No,
to make, so,
no.
you know, so they're gonna, they send us the thing about the size of the sign.
They did not get a variance for the original sign, I can say that. This has been quite the conversation that we've been having around here. If you would like additional information on the original signage application, you'd have to talk to Kip Kaiser, our building inspector. They put in an application for that sign, and they were given a building permit for that sign. So any additional information, I would seek that out at his office.
But that's my responsibility as a board member to get that information.
Are you requesting me as a land use administrator to provide you with that?
I'm not asking you to do anything. I'm just saying, hopefully the applicant shows up with that information, and so that he knows exactly what,
Right.
you know, if he has a sign that is above and beyond what we allow now,
It's-
he should probably come and say, this is what was approved.
In the
and I never
applicant's
got a variance.
defense, they probably didn't know that you were gonna ask that question. You know what I mean? Like, they came for a variance to put up a sign that went over the amount of signage that they were allowed. I don't think they anticipated the two signs in correlation within, I didn't see that coming, and I don't, that's why I stated earlier, like, if there's stuff that you want additional information to, don't be afraid to continue. To say, you know, I need additional information to make a judgment on this particular application. And say, well, and then that applicant, then the onus would be on that applicant to provide you with that information.
You can make that motion, kick the person next to you, make sure they nod their head aye.
I think it's really easy to convince other board members
Yeah.
that this information is important to me. I think we should have this before we make a decision. And I think that there probably be more than amenable if the information that you are seeking is valid, you know?
And Mr. Stevens is back for another visit.
Yeah, this will be the last time.
No, well,
But I still love all you guys, and I'm really, my basic takeaway here, I'm hoping we're kind of learn as we go along, because this is new for a lot of people, but I would request that you request, because I can't request of council, but the board could request of council, the question about burden of proof. And it seems that, you know, from all of the lecture series that we've been to, this is just a ZBA lecture series over the years, that burden rests solely with the applicant. You guys are not responsible for going out on site and checking his measurements. I mean, what he presents is the record, period. You guys made a decision on the record, period, and you shouldn't feel that you have to go back and look through previous decisions or reinvestigate what's happened on that property over the last 50 years. When an applicant makes a application, the burden of proof is on his agents, anybody that's part of that agent group, period. So I would just like to ask clarification, not necessarily on this case, but just how that burden of proof is established. Who's responsible for submitting their information prior to a judgment? Thank you.
So who would you ask that of you?
If you would like that information, that would be legal advice of counsel. I would encourage you to go into a non-public session.
I think we should go into a non-public session so that, I think we should go into a non-public session to know what, in the future, what this will affect on future cases. And this would be a good time, since we have counsel here, to understand that.
Right. I would go through the rest of the agenda and conclude the meeting, and then we could do that at the end. That would be my suggestion.
Okay, next item on the list. If the ZBA would like to continue to receive a comment letter from Glenn Greenwood, the town planner, a motion should be made by a board member. Now,
Could you repeat that?
pardon?
Would you please repeat that?
Glenn Greenwood, this is the kind of middle-aged, we were all middle-aged. Let's start with that. He sits in the planning office, he's there almost every day, but he doesn't live in town. He just works out of here,
Oh, yes,
And he's
I
a
know
town-
who he is.
okay?
I just didn't.
Nice guy, nice enough guy. Have he and I always agreed? Of course not. What a shock. But on the other hand, the guy knows his business. And if he didn't know his business, he wouldn't still be the official town planner person. So you worked with him for how many years, Mark?
I'm sorry, sir?
How many years have you worked with?
Over 12.
Over 12?
He's probably been here 30? 38 years.
I was gonna say, I've been here more than 38 years.
Mhm.
He was here when I came.
Mm-hmm.
How long has he been supplying a comment letter?
Well, you've only gotten one comment letter from him so far. His comment letters are, he's been working with the planning board for 38 years. I have found his comment letters extremely helpful, not only to the applicant, but also to the board. If you'd like to keep receiving those letters, you can take his advice or you can discard it. But it's good professional advice from a man who's been a town planner for many, many, many years. And I work with him every Wednesday and enjoy our time together and our discussions on planning and zoning in general. And I find his advice critical to the planning board process.
So based on that, I motion that we continue to have Glenn Greenwood's comment letters.
I'll second the motion.
All right, now the motion is for Glenn to continue with his comment letters. I'll use the phrase wholesale. In other words, every case that comes in, you want to
If he's willing, yeah.
Correct. I'm sorry, I was answering his question, sir.
say, in my opinion, personally, is that that's a slippery slope for the Board of Adjustment. They're getting firsthand planning board advice on every case that comes before us. Now, if we have a question, want to pose it to them, that he is being responsible on behalf of the planning board, on the Board of Adjustment. But the minute you have too much planning board involvement in Board of Adjustment, the next thing you would not want in there is the Board of Selectmen sitting on top of us. And as a former selectman, I always wondered, what the hell do those people do? They give everything away. You know, that's the reaction of all the other boards in town. Or a high percentage of them. So I consider being on this board to be a privilege for the members, and first of all, you get to see a different side of how the process works, and that there is a remedial process that does not involve going to court, employing lawyers, not that they should starve or anything, but there's plenty of people out there that use their facilities more than we can. So that's just my opinion, but that was the gist of the session we had 2 years ago. I think some of you were here for that, where we had a person come in and do a class on the Board of Adjustment and responsibilities and how it came to be, and so on and so forth, and put on by this some group in the state. They had a little magazine that came with it and everything. I thought it was really helpful. Okay, that's it. Just my opinion.
I have a question. Whose benefit? For whose benefit is Mr. Greenwood opinion letter or help? Is it for us to make a better decision when we're asking him for his opinion? For example, in this last case with the directional signs, is that for us, or is that also for the applicant? I mean, how confidential is that, or is it not?
Well, I've never been asked to answer that question. I would assume that if we're paying on a contracted basis for him to write an opinion for the board, that it's the board's business and the town's business, and not the applicant's business.
Yeah, okay. That makes
so-
sense. Because actually, he's working for Brentwood as a whole, in which the applicant is a part, but it's Brentwood who's hiring him. So I'm saying I agree with you. Not that it matters.
Well, no, it does matter. I mean,
Well, what the lawyer says, of course.
Counselor, do you want to?
Sorry, what's the question?
Okay, the question was, if the board requests Mr. Greenwood to give us an opinion on a case that we're going to hear, is the applicant entitled to a copy of whatever we get from Mr. Greenwood?
Yeah, yeah. Yeah, if under nothing else, certainly under RSA 91A, they would be entitled to a copy of it. Yeah,
Considered public knowledge.
it would be a public record. It would be covered under the Right to Know Act.
So if we do, we should know that, and if we have that on every case, then every case, the opinion we got from him would have to be shared. Or it could be requested.
Yeah. The planner's comments, the planner's comments would be subject to 91A, would be subject to the normal kind of procedures for public documents. The stuff that I tell you isn't necessary because there's an exemption under 91A for your attorney. There's not an exemption for your planning officers.
Okay. Does that answer?
I guess my question would be, is it a comment letter, or is it is it a letter to, a direction letter to tell us how to do
Well,
our job? I mean, it's-
never had
I haven't laid my eyes on any of these comment letters, so.
well, either,
Comment letter to me means, I'm taking it as it's an unbiased, this is his opinion.
I think Bruce is just sitting there just itching to.
Yeah, I'd just like to comment that as long as Glenn's been employed by the town, he writes a comment letter on every hearing before the board. And it's been our practice for, I think I maybe misled you, I think he's actually been here 42 years. And he presents a comment letter for every hearing. And that's, the applicant has to have his plans, Mark, you could correct me, I think 2 weeks prior to the hearing, so that Glenn can review, the plans and then make comment on those plans. And so Glenn's comments are included in every packet that every member gets for the meeting. And we also make extra copies available for interested members of the public to read. And he also sends those comments, his comments, back to the applicant at least 4 or 5 days before the next hearing, so the applicant can come along and, make changes or supply additional information. But Glenn, it's just a comment letter as to legality. It kind of prevents a lot of liability on behalf of the town for making misinformed decisions. And Glenn is so adamant about not making statements, he's just giving his opinion, that he's always, for 39 of the last 40 some odd years, sat apart from the table of the board members over in the corner. Since we've been filming, we've really said, hey, Glenn, you have to sit at the table and to be better heard. But he's always set apart from the board because he didn't want any board members to think that he was telling them what to do. He was just, making comment based on state law, reading the town regulations, and preventing any missteps legally, by the board. So he's served the town so well for so long. But again, he's always adamant to say, I'm not here to tell you what to do. I'm just telling you, based on my professional background and reading of statutes, that this is my best recommendation. But members often, I won't say often, but occasionally somebody will have a different view of a situation. And just like with the planning board, you guys are all, you're an independent board, autonomous board, and you make your decision based on your own judgment.
My concern is that the applicant may see Glenn as more of an authority and less of an opinion maker. And I mean, in that one case, it did come up, and you could tell that they had read Glenn's opinion before. I mean, plaintiffs or applicants, they're different they think differently from the way we do. And in other words, his comment should not be used as evidence saying that this may or may not be true. They shouldn't rely on it as evidence. And I don't know what the applicants think.
Well, most of the applicants that come in, and Mr. Morrill can tell you, an applicant coming before the board is represented by legal counsel and expert witnesses, professional engineers. And so they're not being bowled over by any comments that Glenn makes. I mean, they have their own institutional knowledge and professional credentials to review that information, and very rarely, they actually applaud Glenn writing the comments because it speeds the process up. If you guys were to go to a situation where mechanically you had to ask the professional planner for his opinion or opinion on the legality of the application, how would that work? First, you'd always be continuing meetings, because you would first have to hold the original meeting and then make the decision then. You'd have to make that decision at a publicly noticed meeting. You can't just call amongst yourselves and say, hey, I want Glenn to write a letter this time and not this time. It just seems like it's a template for good, rational decision-making by town boards. So yes, Doug, you've done well by explaining what your opinion on this is, in my estimation.
All right, so I guess the bottom line is, on occasion, we may want to access that resource, but we shouldn't be having it on a daily, hourly, or meeting by meeting, case by case basis. I mean, otherwise, why would they want us here? We just have one make the decision.
Well, I've seen a lot of Glenn's memos over the years, and, you know, I think what Glenn tries to do is give us the crib notes of what the applicant's asking for and spells it out for us very clearly of what the bylaw says, and so that we have right in front of us, not only do we have the application, but we have Glenn's take on what that ask is. And so I've always looked to Glenn's minutes like that he sent to us as just a reference of, there's another person in the town that's telling us what that applicant's asking for, so it might help us clarify what the applicant is actually asking for.
Right.
Because sometimes applicants don't have all the facts in front of them and it's not clear, so Glenn's memo sort of clarifies that.
Okay, counsel, what's your recommendation?
Well, don't look to Glenn for legal advice. Other than that, RSA 673 says that you can appoint a planner to give you advice. It's up to you if you want that advice for every single application, or if you want to make it so that you request that from him. You know, it's your call. Sorry. I can't tell you what to do. I can only tell you that it's, you can go either way, whichever way you feel serves your board better.
Just so you're aware, Glenn he's by contract, okay? So he has contracted hours that he needs to apply. And he's in the midst of writing out a new contract for this year. He's a little late on it. I'd have to ask him how his contract would work if he's just an at-will with the ZBA. You know what I mean? Like, he needs to be able to put that into his contract as amount of hours spent doing this type of work. And so I'm just not sure how contractually I will have to work that out with Glenn.
I think he indicated that is not a problem when he first started to write the last couple recommendations, because again, he's under the town designation as the town planner. There's one set fee that he has, or X number of hours that he puts in. So he's told us that he's willing to, you know, help the board out.
No, I'm just saying if this board decides that they don't want a comment letter for every application, they only want it when they call upon him.
Well, I think
I don't know how to advise Glenn on his contract of how many calls, you know, how many times are they going to want this comment letter from him?
Well, I think based on the frequency of the ZBA applications that come in, that it's definitely a non-issue. It's a nothing burger here. I mean, it doesn't take him much time to do it. He can do that. And I go back to mechanically, if the board solicits his information, you'd have to make that decision at a publicly noticed hearing. So you couldn't just talk amongst yourselves and say, hey, Glenn, send us a note on this case, but not on that case. You'd have to hold your application hearing, make that decision, that vote, and then continue your meeting for another month or however often you meet. And it just seems it would slow the whole process. And if the town is paying for solid legal interpretive advice, why would we put the townspeople, taxpayers, in jeopardy by trying to make decisions with not having perhaps all the facts or understanding of the laws and the statutes that apply to that application? It just seems like it's a win-win for the taxpayer and for everyone. But I agree, you don't have to do it. But again, it seems like it's a good deal for taxpayers and the applicant. If you want to further businesses working in town, then you don't want to just have another roadblock of another month.
Okay, so the consensus of the board is? Well,
So I'll go back to my original, I motion that we approve Glenn continuing his comment letters on everything that comes in front of the board, I guess.
I have that motion and I have a second by Wayne.
So I say we vote on it.
okay, we have a second,
Wayne.
okay? All those in favor?
Aye.
I'll abstain. Opposed? What's that give us?
2-1.
Okay, then I guess the two takes it. Okay. Any other business that may legally come before the board? Now, Mr. Administrator, what else do we have?
A non-public,
Non-public.
if that's what the board chooses to do.
Okay, do we have a motion on the board to go into non-public?
To go into a non-public, you'd have to have a motion and then a roll call vote, sir.
Mm-hmm.
So a motion to go into non-public.
We have a motion to go into non-public. And we have a second. Okay, and call the roll.
Yeah, you have to do a roll call vote.
Okay, you don't have to call the names, it's been,
No. Just go around the table.
okay,
Frank Albert, Vice Chair.
Aye.
Aye.
Wayne Morrow, member, yes.
okay. The ayes have it.
You vote, sir?
I'm going to abstain.
Abstain from going into non-public?
No, I will vote to go into non-public.
Rankin Elliott, vote for no.
Aye.
Oh, yeah, shut these off.